The second thing that I learned about was Bill Walker's lawsuit. And I'm not a lawyer. I'm a generalist. And when I saw what he had done, to me, as a non-lawyer, it was just a failed attempt at getting something done through the courts, and I didn't understand the implications of what happened. When I contacted Bill through the internet, he confirmed that this article that I read that I didn't like, he was the source for the article, and in fact it was the truth. And the title of the article was "The Constitution Null and Void," and that was really that got my attention. Further, he actually explained to me what the significance of his writ of certiorari going to the Supreme Court meant.
We kind of assume that they're in violation because they have not acknowledged this this record, this collection of records and applications. And it is the legal question that they haven't violated the law because they haven't read it? Is there any proof that we have that they've laid eyes on these records? Have they ever signed off on this?
That's a good question. Yes, they have read it, and the proof is in the writ of certiorari that Bill filed on the case called Walker v. Members of Congress, filed in 2004.
Bill, in the Ninth Circuit Court case, in that ruling, was there ever any discussion about the count that you had come up with? Were any of those thrown out? Did they come up with a different total number than you?
No, they see, I filed two lawsuits, one in 2000 and one in 2004. I got the first piece that I needed in 2000 when the government acknowledged that my count of applications was correct. They basically complained and says, well, there's no way to really verify all these, but they did not state that they were not false. Being all in the congressional record, it'd be almost impossible for them to refute it under rules of evidence. The second thing that happened in the appellate court, and a lot of people don't realize it, that's where this case got won, was that it was a very strange situation with members of Congress. When I filed it, I went to the district court, and I expected the district court to do exactly what it did, was they found exactly what had been found in the first case. And the government never showed up, literally. They just never made an appearance. So I appealed it, and I went to the appellate court. So finally, at that point, up shows a representative of the federal government saying they're going to oppose this. And I said, okay, well, you know, it's a little late for you to show up. The rules of the court are real plain. You got to have showed up at district level, and you didn't. And they say, well, we're here to we're here representing the, you know, we're here. We have a right to be here. And I said, no, you don't. And this is all going in motions back and forth before the court. And I finally said, look, the law says real clear, you have to express and state, who are you representing? Who are your clients? What instructions do you have? That's what the law says. You can't just show up as the Department of Justice and say, hey, guys, we're here. And the court ordered the United States to declare who was their clients. Who were they representing? And that was the key point made. The government of the United States officially and formally stated that they had letters of instruction from both the Senate and House consuls for the Department of Justice to represent them. Well, the law says very clearly they can only have that done by those two consuls if they are voted on by the members of Congress. That is advocating. They are instructing them to not to accept the premise of it, that they were doing it. So now I had an official record stating that the members of Congress were publicly, because this is a public record, publicly opposing the Article 5 convention call. So now, when I went to the Supreme Court, the attorney of record that John mentioned earlier was the Solicitor General of the United States, acting as attorney of record and as officially as attorney of the Solicitor General. And the rule he refers to was that before the court could decide to accept the case, it had to have fact and law set out. It requires the defendant has to say this is wrong and this is why. The federal government did not. It waived, and I put 4 stipulations in that thing. I said, 1, the call is peremptory, meaning Congress can't refuse to do it. 2, it's based on a numeric count of applying states with no other terms and conditions, meaning that rescissions, time limits, so on and so forth, the things you mentioned earlier, don't apply. 3 is that there are sufficient number of applications to cause a convention call. And 4, that there was a violation of oath of office for Congress not to call. The attorney of record for the Congress, acting under federal laws in which he had to have consulted with Congress, waived, which meant that he said, under the rules of the federal court, which is also federal law, yep, you're right as to fact and law. So now I had them cold. They had agreed that it was a violation of oath of office and that all the conditions necessary to cause a convention call existed.
I think the idea of having all of Congress get together and find joint representation for their defense is an amazing event. And was this ever covered on by any mainstream media or even fringe media? John or Bill, has anybody ever attempted to cover this?
No, they actually. So that was their stupidity.
And John, I take it you went to go to some news outlet along the way, and what kind of response did you get?
I don't care. Ignore it. You know, it's hard to believe